Historically, education for people of color has been flawed and wrought with conflict. We as a group examine the impacts such conflicts have had on the African American community within the United States.
Plessy versus Ferguson was an infamous case of separate but not equal accommodations for African Americans. In the mid-1800s, African Americans were legally allowed freedoms through the 14th and 15th Amendments. Unfortunately, in the South, whites found a way around these laws, like using literacy tests to keep the African Americans from voting. Although the Constitution provided equal rights, African Americans were still being separated in businesses, schools, and transportation. 1890 brought Jim Crow segregation laws. Louisiana was one of the first states requiring separate accommodations for blacks and whites on trains. There was a significant disparity in each set of cars. The white's car was roomy, had overhead bins, cushioned seats, people were dressed respectably and were polite. The colored cars, or Jim Crow cars, were behind the locomotive and reeked of smoke. They had wooden seats, were dirty, had no space for luggage, and were commonly occupied by drunks. In 1891, the Citizens Committee to test the constitutionality of the separate car law had been established to fight the unjust Jim Crow law. A few months before the Plessy incident, they recruited Daniel Distoons. He bought a first-class ticket from Louisiana to Alabama. When he arrived, he sat in the white railroad car and proclaimed he was black. He was arrested, but unfortunately, when it came to trial, his case was dropped. Segregation of railroad cars was a state law and did not apply to trains going across state lines. In June 1892, the Citizens Committee recruited another person to help the cause, Homer Plessy. He was a light-skinned New Orleans Creole with 1/8 African heritage. Wearing a suit and hat, he purchased a first-class ticket from New Orleans to Covington, Louisiana. He sat in the white car, and when asked for his ticket, he told the conductor he was black. He was told to move to the colored car, and when he politely refused, he was immediately arrested. The DA's defense was the Jim Crow law. He claimed it was just as illegal for whites to ride in the colored car as it was for blacks to ride in the white car. He also stated that people were more comfortable riding with others of the same race, although I'm sure he was more concerned with the comfort of whites. Attorneys for the defense cited the 13th and 14th Amendments directly contradicted the Jim Crow law because it made blacks feel less than, and that they should be given the same rights as white citizens. They also tried to attack the subjectivity of the law since it was most often based on skin color and not ethnic heritage. Lastly, they went on to explain that Plessy was not disorderly and even agreed to be arrested. There was no reason to send him to the colored car. In the end, Plessy was convicted. Judge John Howard Ferguson determined the state of Louisiana could legally segregate the railroad cars. Plessy appealed the decision. In 1896, thanks to Judge Harlan's infamous dissent, the Supreme Court determined separate but equal facilities did not violate the 14th Amendment. This case legally justified racial discrimination and segregation, and enforced the Dred Scott decision confirming that blacks were not U.S. citizens. However, the NAACP made it their mission to attack the separate but equal law through segregated schooling.
Another key case, which was part of the NAACP's coordinated strategy to dismantle segregation, was Gaines versus Canada, which targeted the law school at the University of Missouri. Lloyd Gaines was a black applicant who, although qualified to attend, was denied admittance by the school's registrar, Psi Canada, due to race. It was admitted on trial that petitioner's work and credits at the Lincoln University would qualify him for admission into the School of Law of the University of Missouri if he were found otherwise eligible. The school's counterproposal, per Missouri law, was to send Gaines to an adjacent state which admitted non-resident Negroes to their law schools. The state argued that it was committed to providing equal but separate education to its Negro students. Until there was sufficient demand to build a law school for black students, Missouri's practice of sending them out of state met the legal requirements of separate but equal allowed by Plessy versus Ferguson and other relevant court cases. NAACP attorneys on behalf of Gaines argued that for one intending to practice in Missouri, there are special advantages in attending a law school there, both in relation to the opportunities for the particular study of Missouri law and for the observation of the local courts, and also in view of the prestige of the Missouri Law School among the citizens of the state, his prospective clients. This argument was part of a larger NAACP effort to attack the equal portion of separate but equal, with upper southern states being prime targets. States like Virginia, Maryland, and Missouri were culturally and geographically southern, but due to northern influences enforced a grayer interpretation of segregation and possessed a conflicted cultural personality. On December 12, 1938, the U.S. Supreme Court found 6-2 in favor of Gaines, largely agreeing with the position presented by the NAACP. The case was remanded back to the Supreme Court of Missouri with direction to start new proceedings that aligned with the U.S. Supreme Court's decision. While Gaines v. Canada didn't have as profound an impact as Plessy v. Ferguson or Brown v. Board of Education, the Gaines v. Canada precedent removed one brick from the wall of segregation: the validity of providing a graduate-level education to white students, but not providing the same in-state opportunity to African American students. This, in theory, required the states to either incur the expense of building schools and related infrastructure, for in many cases a small number of qualified black applicants, or to integrate African American students into white campuses if there was no equivalent facility for them. This was a major turning point in the argument that, at least in the case of specialized graduate programs serving whites, that separate could be equal. Ironically, Lloyd Gaines disappeared a few months after the decision. At the time, and to this day, there are competing rumors and theories as to whether he was murdered or voluntarily disappeared. Certainly there was no shortage of blacks who met with violent ends due to some real or perceived affront to white sensibilities. However, the possibilities are muddled due to several factors, including his conflicted enthusiasm from being used as a civil rights test case, his habit of taking off for extended periods of time without communicating with family, and perhaps most confusing, his last letter to his mother, in which he states, "Should I forget to write for a time, don't worry about it. I can look over myself okay."
While Griffin v. Prince Edward County was filed and ruled on in 1964, the story of this particular Supreme Court case has roots that stem more than 10 years prior. In 1951, Farmville, Virginia had a white high school and a black high school. Farmville High, the white school, had plenty of classrooms, a gymnasium, cafeteria, infirmary, and other modern resources. Robert R. Moton High School, named for the Prince Edward native who succeeded Booker T. Washington as president of Tuskegee Institute, had none of these. School supplies were secondhand and spread thin at Moton High, and more than 450 students were packed into a tar-papered facility that was built to only hold 180. This became a glaring difference for the black students of Moton High to that of their white counterparts' experiences at Farmville High. Barbara Rose Johns, a teenager at Moton High, organized a strike at her school using non-violent civil disobedience to draw attention to the unequal learning facilities that black students were facing in Prince Edward County, Virginia. While this week-long strike was being carried out, Barbara and other fellow students, one being Dorothy Davis, sought legal counsel from the NAACP in Richmond, Virginia. The NAACP agreed to assist the teenagers as long as the suit would be for an integrated school system and not just one about equal facilities. A month later, the NAACP filed Davis v. County School Board of Prince Edward County in federal courts. Unfortunately, the court upheld segregation in Prince Edward County, and the NAACP appealed to the Supreme Court. Davis v. Prince Edward County, along with 4 other cases, became part of the case Brown v. Board of Education. As Davis was the only case in Brown initiated by a nonviolent student protest, it's seen by some scholars as the beginning of the civil rights movement. In response to the ruling by the U.S. Fourth Circuit Court of Appeals to desegregate the schools, Prince Edward County's Board of Supervisors votes to avoid desegregation by not funding public schools in the 1959-1960 school year. Furthermore, Virginia Senator Harry Byrd promotes a massive resistance campaign which turns into a state program whose sole purpose is to enforce segregation. This massively resistant approach lasts in Prince Edward County for 5 years. and it was the only community in the entire nation to do so. It took a series of petitions, federal entreaties, and ultimately another Supreme Court case to provide schoolless black children some relief. In 1959, a prominent African American minister and local NAACP chapter president, Reverend Leslie Francis Griffin, filed the lawsuit Griffin v. County School Board of Prince Edward County on behalf of his children. Students and community members continue to protest the fact that over the past 5 years, they have had no access to formal education, and the massive resistance program is targeting the African American community. President John F. Kennedy condemns Prince Edward County for closing its public schools in his statement to Congress. A month after the president's statements, his brother Robert Kennedy visits Prince Edward schools on March 18, 1963, and makes the following statement. We may observe with much sadness and irony that outside of Africa, south of the Sahara, where education is still a difficult challenge, the only places on earth known not to provide free public education are Communist China, North Vietnam, Sarawak, Singapore, British Honduras, and Prince Edward County, Virginia. Free schools opened in Prince Edward County in 1963. The Free School Association hired teachers, bus drivers, and administrators from all over the country. It was the most integrated school system in the state at the time. In a single month, 4 abandoned school buildings were opened and cleaned. Textbooks were donated from publishing houses and private collections. School bus engines were started for the first time in 4 years. The association also received $1 million in donations for the operation of the schools from sources all over the country, including a personal donation of $10,000 from President Kennedy. Yet, even with all of these resources coming into Prince Edward County, there were still hundreds of children that didn't have access to education. On May 25, 1964, the U.S. Supreme Court in Griffin v. School Board of Prince Edward County rules that the county has violated the student's right to an education and orders that the county immediately reopen its schools. However, it would be decades before Prince Edward public schools were truly integrated.
In the 1930s, the NAACP adopted policy of seeking desegregation in school cases rather than focus on equal facilities. W. E. Du Bois opposed this policy, not so much because he was against integration, but because he believed the better path was to seek equality first through the black schools. Brown was actually the consolidation of 5 cases from around the country. The actual Brown case sought to enjoin enforcement of a permissive segregation statute in Topeka, Kansas. Although finding that segregated education has a detrimental impact, the lower court refused to grant relief based on the assumption that the educational facilities were equal. The Briggs plaintiffs initially petitioned the school board for Clarendon County, South Carolina, for equal facilities, but after this was denied, brought suit seeking integration. The lower court found that the schools were unequal and ordered equalization, and the case went to the Supreme Court on the question of the constitutionality of separate but equal. Like the Briggs case, the Davis court held that the segregated school systems at issue were unequal, but still refused to hold separate but equal unconstitutional. Unlike the other cases, which were all brought in federal courts, the Belton case was brought in Delaware State Court. Also unlike the other cases, the Delaware court granted relief in order that the plaintiffs be admitted to white schools. One of the attorneys in the Belton case was Lewis Redding, who was the first African-American attorney admitted to the Delaware bar. The Bowling case involved African-American students in the District of Columbia. Because the 14th Amendment does not apply in the District of Columbia, the Bowling case sought relief under the 5th Amendment's Due Process Clause rather than the Equal Protection Clause under the 14th Amendment. The Supreme Court issued a separate opinion on the same day as Brown, but the Bowling case is generally considered a part of the Brown cases. Brown was initially argued in 1952 when Fred Vinson was the Chief Justice. However, Justice Vinson died prior to the re-argument of Brown in 1953, and Earl Warren became the Chief Justice, which likely had a significant impact on the outcome of the case. The re-argument in Brown lasted for 3 days from December 7th through 9th and took 11 hours. The court issued its opinion on May 17, 1954. An important distinction between the Brown case and the cases that preceded it was that the schools at issue in Brown were either deemed equal or had been ordered by the lower courts to be equalized, leaving the separate but equal question as the sole focus of the Brown case. In making its decision, the Brown court relied on evidence from a number of prominent psychologists who had testified in the underlying cases about the harm caused to minority children through segregation. The court unanimously concluded that in the field of public education, the doctrine of separate but equal has no place, and that as such, separate educational facilities were inherently unequal and in violation of the constitutional principle of equal protection under the 14th Amendment. The court then set the case for further argument on the remedy. A little over a year later, the court issued a second opinion on the remedy and ordered that steps be taken to end segregation with all deliberate speed. Unfortunately, as history has demonstrated, this language left a lot of wiggle room for states to put off compliance, which only gained momentum with the passage of the Civil Rights Act nearly a decade later. The Brown decision was met by massive resistance, and in particular in the southern states. As Professor Carson noted in a 2004 article, 10 years after Brown, 98% of black students in the South continued to be segregated. In many respects, probably the larger impact of Brown was that it provided the spark needed by the country and the civil rights movement to end Jim Crow in the South and to obtain laws with some teeth to enforce civil and voting rights for minorities. As the civil rights movement stalled in the 1970s and 80s, prominent African American professors such as Professor Claiborne Carson at Stanford and Derek Bell at Harvard began to question whether the NAACP's single-minded focus on desegregation as the sole remedy for public education had been short-sighted given the continuing de facto segregation and the huge disparity in economic and educational resources received by minority students versus non-minority students. In fact, as Derek Bell noted in his Serving Two Masters article, the NAACP strategy presented a potential conflict with what many black leaders and students wanted more than anything else, which was a quality education, no matter how delivered. This problem was further exacerbated by the fact that Brown has not ended segregation, as subsequent court opinions have refused to uphold segregation measures when the segregation is not the result of an intentional policy, as reflected in cases such as the court's 1974 Milliken opinion or its 2004 Parents Involved opinion. As Professor Bell has noted, neither the NAACP nor the court-fashioned remedies are sufficiently directed at the real evil of pre-Brown public schools, the state-supported subordination of blacks in every aspect of the educational process. As Professor Bell also noted, whether based on racial balance precedents or compensatory education theories, remedies that fail to attack all the policies of racial subordination virtually guarantee that the basic evil of segregated schools will survive and flourish. From an interest convergence perspective, the interests of affluent and white society have not been sufficient to force the United States Supreme Court to order segregation across districts in order to remedy white flight from black school districts, as reflected in the Milliken v. Bradley opinion and the Parents Involved in Community Schools opinion. As both Professors Bell and Carson noted in their articles, perhaps we should look back to the words of wisdom spoken by W.E. Du Bois in 1935. Theoretically, the Negro needs neither segregated schools nor mixed schools. What he needs is education. As W.E. Du Bois goes on to say, while mixed schools are ideal, in the short run, the goal has to be obtaining a quality education now, however it can best be accomplished.
Busing in the United States was a direct response to the 1954 Supreme Court decision Brown v. Board of Education. Busing was the practice of taking diverse groups of children from differing parts of a school district and enrolling them in the same school. Boston became the epicenter for the pro and anti-busing ideologies. In the middle of the 1970s, the city's public school system was highly segregated. 80% of African American pupils attended Black majority schools, and more than half were enrolled at schools that were over 90% Black. Both sides of the issue appealed to American values and identity. The pro-busing people saw their movement as America's natural arc towards a more perfect union, and the anti-busing people saw their sentiments as being appealed to the American notion of individual freedom and liberty. The following are just a couple of pictures from the 1970s in Boston. The first one is a anti-busing advocate attacking a pro-busing advocate with the American flag. This slide is a photo of a pro-busing rally in the heart of Boston. Most of the attendees were Black, and they advocated and argued that busing was a civil rights issue and a way to correct centuries of oppression in America's schools. And finally, this photo is a picture of anti-busing advocates in Boston, and with the caption here, "Whites have rights too." The busing issue in Boston led to great socio-ethnic tensions throughout the city. So what happened in Boston? Instead of equalizing the city's public schools, the issue inflamed ethnic and racial tensions in the city. In South Boston High School, that was predominantly poor and white, a federal judge ordered the junior class to attend Roxbury High School, which was predominantly poor and Black. Instead, only 13 of the 550 white students attended Roxbury High, and Roxbury High, that was predominantly Black, only 7% of the 1,300 students attended the white South Boston High School. Busing in Boston didn't work. While busing was in response to the Brown decision, it did have a mixed effect. And on one hand, it did inflame racial tensions and saw violence throughout the city, but yet on the other hand, it did put Boston on a path to greater socioeconomic equality in the city's school systems. To this day, Massachusetts overall has one of the best public school systems in the United States, and Boston urban public schools are among the best public schools in any urban part of the United States. So overall, it was a mixed effect, and it left a legacy of hurt feelings, but it did put Boston on a path to greater educational equality.